kicked off. Welcome everyone to today's webinar on New York State Paid Sick Leave Proposed Regulations presented by Barclay Damon. Many thanks to our presenter, Chris Harrigan, for being with us today and all the participants who have joined in. We'd also like to thank our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. Chris will share the presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation, and just a reminder when others are speaking to please keep your audio on mute to minimize background noise. With that said, I'll turn things over to Chris to kick things off.
Thanks so much. For those of you that were expecting Mike Sciatti today, he did not get better looking overnight. Instead, he had Mike's got pneumonia and can't speak. So I'm pinch hitting for him with all of you this morning. So welcome. Thanks for joining us. Today, we're going to talk about the proposed regulations. And I don't have control. I can't change this. Have you got that up there? The
yes.
Presentation.
Okay. There we go.
Let's see. Okay. So today we're going to talk about the New York Paid Sick and Safe Leave Act, and there, as many of you probably know, there are proposed regulations that have been submitted by the Department of Labor. Those proposed regulations are talk about a bunch of different things that we're going to go over, including counting and leave requirements, accrual calculations, employee documentation rules and regs, and then there's a use rule clarification. These proposed regs are open for comment until February 7th, after which the state will take a look at those comments, make any revisions that it deems appropriate, and then implement those regulations so they are in place on a going forward basis in connection with the new Leave Act. Just as an aside, and as you're probably all experiencing already, this is going to take some getting used to, both the act as well as these regulations. This is it wreaks havoc on leave time. It's been difficult to manage in connection with already existing leave policies. And it's going to be something that we're all going to be looking for bright lines, and it's going to take some time, I think, through a year of experience to really understand the rhythm, figure out all the pitfalls that we haven't seen already, and make adjustments accordingly. So the state didn't necessarily do employers any favors in respect to making this easy by implementing this law the way they did, but be that as it may, here we are. The good news today, too, is I don't think we're going to go terribly long, so we'll have time for any questions afterwards. And also, feel free if there's something you don't feel comfortable bringing up in front of the group, or you think about after we're done, my contact information, I think is on here, and you can feel free to email me or give me a call, and I'm happy to answer questions or help out any further. So. Without anything further, let's get started. So the first thing in the regs are counting and leave requirements that they talk about. So for 4 or less employees that have less than $1 million in net income, each employee shall be provided with up to 40 hours of unpaid sick leave in each calendar year. So 4 or less than $1 million. It's unpaid leave of up to 40 hours. 4 or less and more than $1 million of net income, that 40 hours of unpaid leave, as we know, becomes paid sick leave. Paid sick leave. For employers with 5 up to 99 employees, for those in any calendar year, they'll be provided with up to 40 hours of paid sick leave in each calendar year if you've got 5 to 99, so 40 hours of paid. Sorry, let's see here. So for 100 or more, and as we all know, for 100 or more, that number gets bumped up to 56 hours of paid sick leave in each calendar year. So counting employees. So the number of employees employed by an employer during any calendar year is determined by counting the highest number of employees concurrently employed, so employed at the same time at any point during the calendar year. So if you've got a calendar year and as of the middle of July, you've got 100 employees at the same time that are employed, and that's the high point, for that week of the year, and all other weeks are less than 100 employees. For purposes of counting, you've got 100 employees. So it's employees concurrently employed at the same time at any point during the calendar year to date. So where numbers increase, for employers that increase the number of employees during the calendar year above any threshold contained in 196B1, and 196B1, again, that's the statutory section for New York paid sick leave. So if you increase that number, there's a couple things to consider. So the first is the accrual of additional required leave up to the entitlement amount in 196B1 shall be prospective from the date of the increase. But what it doesn't do is it does not entitle employees to any reimbursement for previously used unpaid leave, or to use more than the maximum amount of leave set by the employer in accordance with 196B6. So in other words, if you've got people that are if all of a sudden your numbers change such that the unpaid leave becomes paid leave, then there's no reimbursement for that. And furthermore, to the extent that your numbers change and all of a sudden that you're bumping up against the maximum threshold that's already been used, people don't get more. We all know how this works. You're going to have everybody, all of your employees will be testing the limits and coming up with creative things that we could spend a month of Sundays trying to think about scenarios. And of course, the first one you'll get will be the one that's incredibly unique and creative, and we'll have to cross that bridge when we get to it. But these are the kind of things that these regulations are thinking about. They want to make sure that there's no reimbursement for unused unpaid leave, and that people can't go over the maximum, even in situations where you've got a seasonal employment situation or something else where your numbers are increasing during the year. So important to know. The second thing to consider is prior accruals of used and unused paid leave and used unpaid leave in a calendar year. They may be credited by an employer toward any increased paid leave obligations under 196B. So if you increase, you can use your used and unused paid leave and used unpaid leave as a credit towards those obligations. Employers may not credit any prior accrual of unused unpaid leave toward any paid leave obligations. So that's an important distinction to recognize as well, that if it's unused, it's accrued and unused unpaid leave, you can't use that to offset any new obligations that you have towards paid leave, because you are increasing the number of employees that you have that moves you from one threshold into the next higher threshold. And then the third consideration is employees, they shall retain all existing accruals of paid and unpaid leave, notwithstanding an increase in the number of employees during a calendar year. So in other words, and this makes sense. This is a common sense approach. If there's an increase, nothing happens to an existing accrual. The existing accrual is what it is, regardless of any increase in employees that leads to moving from one threshold to another as it relates to the leave requirements. moving forward with counting employees, reductions in the number of employees working for an employer, that also shall not reduce leave entitlements under 196B, not during the current year, only for the following calendar year. So once you've got, if there's a leave requirement at a certain level during one calendar year and there's a reduction, then it can affect what's going on in that calendar year. You've got to wait until the next year. And employees on paid or unpaid leave, including sick leave, leaves of absence, disciplinary suspension, or any other type of temporary absence, they're counted as long as you have a reasonable expectation that they're going to return to active employment. So, that's going to be a case-by-case basis. You could have situations, and we've all seen them and we all know them. You might have somebody who is on a disciplinary leave, pending an investigation, and you have a pretty good idea that person's never coming back to work because you know how the investigation is going to work out, or you have a pretty good idea and it's going to result in a termination. Or you've got somebody who is out on sick leave. It's been long-term. You've had back and forth with them and have been engaged in discussion with them about coming back. You've been given the high sign that they're probably going to be going on permanent disability and will never be able to return to work. You won't have a reasonable expectation that that person will be returning either. So they won't be counted. But everybody else, they're out on COVID leave, they're out on maternity leave, they're out on a 5-day suspension, they're out because they just had surgery, whatever the case may be. You assume they're coming back and you have no reason to believe that they're not coming back. It's a reasonable expectation. They have to be counted. Also, if there's no employment relationship, as when an employee is laid off or terminated, and whether it's a temporary layoff or permanent termination, permanent separation from employment, that person's not counted. And so, that you might say, well, why would we count anybody that's not employed? Well, in this day and age, especially in the world of COVID, where we've got things like, we've got temporary layoffs, we've got furloughs, that's important. Also, to the extent that you've got seasonal employment and it's during the time in the year, if the count time is the time where you're reduced, any of those seasonal employees that aren't currently employed, you don't have to count them. You might have to count them going back when you're looking at your highest level of employment concurrently during any 12-month period. But if that time that you're looking at is when you've got a reduced number, they don't count for the purposes of counting during that period. And also part-time employees are considered to be employed each working day of the calendar week for the purpose of counting to reach these thresholds we're talking about. Employees jointly employed by more than one employer must be counted by each employer, whether or not they are on the employer's payroll records for purposes of determining each employer's leave obligation under 196B. This proposed regulation is going to get a tremendous amount of blowback. We've seen in the areas of joint employment, we've seen in the areas of joint employment, there have been some I'll call it pro-employee strides made during the current, the Trump presidential administration. Expect that when the Biden administration takes over and gets set up, that you'll see more of what you saw during the Obama administration, and that is that joint employment will become something that's more prevalent. It will become something that is more liberally applied. And so this piece, this joint employment regulation as it relates to counting, this is already getting a significant amount of blowback from people out there who are submitting comments from interest groups and the like. I'm not sure how many people on here on this this Zoom conference have joint employment scenarios, but to the extent you do, something to be aware of, especially if you're not the actual W-2 employer. You still might be on the hook as it relates to paid sick leave for purposes of counting. Important to know. So let's talk next about accrual calculations. So proposed rule number one is that employee accruals of leave must account for all timed work, regardless of whether the time worked is less than a 30-hour increment. So again, regardless of whether it's a 30-hour increment, the accrual is for all timed work. So number two, for the purposes of calculating accruals for timed work in increments of less than 30 hours, employers may round accrued leave to the nearest 5 minutes or to the nearest 1/10 or quarter of an hour, provided that it will not result over a period of time in a failure to provide the proper accrual of leave to employees for all the time they have actually worked. Again, important for people that are working less than 30 hours. This is something that those of you that are, have any involvement with time and scheduling and just it's giving you a headache already as you're thinking about rounding to the nearest 5 minutes or quarter of an hour. Just keeping track of all this is going to be a bear, to say the least. But important to know that if they work less than 30 hours, you may round it to the nearest 5 minutes or to the nearest 1/10 or quarter of an hour, and that's okay to do, so long as that's not somehow going to it's not going to mess up their accrual for the time that they've actually worked. So it's rounding up, not rounding down, and making sure you're not taking anything away from them as they would otherwise be entitled to in connection with accrual for paid sick leave. The next issue is employee documentation, and this is one that we've heard a significant amount of questions and issues that have come up from employers. A lot of it has to do with the carryover of when this went into effect and then COVID and how to manage that. Also the 3-day rule is one that is it's making things difficult for employers and also, as we know, especially if you've got larger workforces and even smaller workforces, if you give some employees, not all, but some employees an inch, they'll find that crack, they'll find that they'll find that hack, if you will, and they'll take a mile. And so, we've seen a lot of people testing limits as it relates to documentation, and something that we've got to actively manage. So in terms of the proposed regs, let's talk about the employee documentation rules. So there's an inquiry limitation. An employer may not require the disclosure of confidential information relating to a mental or physical illness, injury, or health condition of such employee or such employee's family member, or information relating to absence from work due to domestic violence, sexual offense, stalking, or human trafficking as a condition of providing sick leave. So, look, this is a fine line, right? For somebody, and we know the classic scenario is somebody's out under your policy, they're required to provide medical documentation, and the medical documentation that they provide is incredibly ambiguous and is incredibly non-specific in terms of the reason why they were out of work or any indication as to how that somehow rendered them, unable to work during that time. So, this is going to be something that again, it's going to be difficult to manage. It's something that we're going to have to try on a case-by-case basis. But we've got to keep this in mind going forward in terms of the inquiries that we can make in respect to the documentation that we are requiring employees to provide for when they're out sick. So what the heck does confidential information mean? Confidential information means individually identifiable health or mental health information. including but not limited to diagnosis and treatment records from emergency services, health providers, or drug and alcohol abuse prevention or rehabilitation centers. It also means information that is treated as confidential or for which disclosure is prohibited under applicable law, rule, or regulation. So if it's got anything to do with any of these personal identifiers, it's not something that you can require. There's going to be some gray area in terms of what we can get, because you've got to have something that demonstrates that there was a need to be seen, and you like to have something that says anything more than I was seen by a doctor, and leave it at that. Something that we're working on, something that there's going to be a lot of commentary as it relates to this proposed regulation, and we'll see how it all plays out. But important to keep in mind as we implement this and navigate through this new law as it relates to our workforces going forward. So additional proposed rules is that an employer may not require medical or other verification in connection with sick leave that lasts less than 3 consecutive previously scheduled workdays or shifts. And this one, this one is tough for obvious reasons, because it's almost like the honor system, and we don't necessarily like the honor system in some scenarios as it relates to people being out, because they'll be out for any reason but the fact that they were sick, and if they can use this as a mechanism to extend weekends, extend holidays, etc., they will. So it's something that again has to be navigated and considered on a regular basis, and will be not so much fun to deal with in 2021, and I'm sure you're seeing this already. Next, no employer shall require an employee to pay any costs or fees associated with obtaining medical or other verification of eligibility of use of sick leave. They don't have to pay for it. You can't require them to go get something that they're going to have out of pocket for. And then additional documentation rule is that no employer shall require an employee to provide confidential information, including the nature of an illness, its prognosis, treatment, or other related information, nor shall any employer require any details or information regarding leave taken pursuant to 196B4A3 of the labor law, which is otherwise known as safe leave. An employer may, however, it may not require that the attestation explain the nature of the illness or details related to domestic violence, sexual offense, family offense, human trafficking, or stalking that necessitates the use of leave. So you can't ask them to expound. You can't ask them to explain. This is going to be a new world that we're living in terms of people providing the minimum information as it relates to these types of leaves, and it will be it'll be a challenge to have to combat against abuses and recognize when things are being done fraudulently and respond to those scenarios accordingly. So interesting times. So except where prohibited by law, an employer may request documentation from an employee confirming their eligibility to take sick leave under this section of the labor law, where the employee uses leave for 3 or more consecutive and previously scheduled work days or shift. So once it's over the 3 days, you can request documentation that confirms their eligibility, and it can be for those 3 consecutive days, including previously scheduled days. An employer cannot require an employee or the person providing documentation, including medical professionals, to disclose the reason for leave, except as required by law. Requests for documentation they've got to be limited to the following, and many of you have heard this already. The first is an attestation from a licensed medical provider supporting the existence of a need for sick leave, the amounts of leave needed, and a date that the employee may return to work. Or an attestation from an employee of their eligibility for leave. So you can require either of those. And again, this is going to be one where we all know situations where certain employees have physicians that are friends or that are family, and we've seen those types of abuses occur in the past. I think that it's fair to say you may see some of that now. If you haven't experienced it already, assume that you're going to get the absolute minimum in terms of what's set forth in these attestations, and it'll be something that we've all got to navigate through and be careful about, and it'll be a challenge at times. So let's talk about there's a usage rule clarification as well that's important to note. And that relates to preventative medical care and what preventative medical care means. So preventative medical care means routine health care, including but not limited to screenings, checkups, and patient counseling to prevent illness, disease, or other health problems. So there's a question of what that definition meant. This further clarifies it. I think it's still very general, and you could drive a truck through it, but be that as it may, that's what we have from the state so far. And again, these comments are open until February 7th, and then we'll see, what the state does, if anything, with the comments in terms of providing additional supplements or revisions to these proposed regulations. I believe that's it as it relates to the presentation itself. And I'm happy at this point to entertain any questions, and we've got some time. So let's see, I think I've got one here on chat. So this is a question that says, we got a couple up here. We have an employee whose wife is expecting in March. She has only been employed since November, so does not qualify for PFL. Can he use sick leave for the birth of his child? So the answer is maybe. So he's been employed, so he's not entitled for paid family leave. When you say can he use sick leave for the birth of his child, are you talking about sick leave within your own company policies or sick leave under this current law? If it's the current law, the answer is I think so, and I can confirm that for you, and we'll see what that means. But I think the answer is I think so. The next is this policy for us replaced our PTO policy, so it's okay to allow people to take this as vacation time rather than being sick. And what I'd say is a lot of people are doing that. You're seeing that occur. The part that's difficult is that if you are having it replace your PTO policy, understand that you're going to have situations as it relates to, you have to make sure that you have it documented somewhere where it, if you can, where it really is a vacation as opposed to, a sick. And the other thing that you've got to keep in mind as well is that if you've got a number, whether you're at the 40 number or the 56 number that they're allowed by the statute to use as sick paid leave, and they run into a situation where they take a week off for PTO, they go away for vacation with their family, and then they subsequently get sick, and by using the vacation, now they've exhausted their 40 hours or their 56 hours. You're going to run into a problem if you say, well, now you've already exhausted your time because of that vacation you took. We counted that against your 40. that's likely not going to work for purposes of paid sick leave, because the statute doesn't care or contemplate the fact that you're using it, it's replacing your PTO. They still get that sick leave if the reason is they're sick. So something to keep in mind. Going through these questions again. Can you clarify proposed? When specifically should it have started? So again, I think what you mean is I'm assuming you mean proposed these regulations. So again, the Paid Sick Leave Act is in place. That went in place in the fall, as we all know. These are regulations that the state puts in place that further clarify the rule. Every law in the state of New York has the statute itself, and then there are usually regulations that go along with the statute. The regulation provides some additional detail, some additional clarifications. What we're talking about here today is these regulations are proposed. They're not finalized yet. They haven't been officially adopted. They are just proposed. The state has given people until February 7th to provide comments. They've got to do that by law. They've got to have a public comment period. And then after that public comment period, they review the comments, and sometimes they make changes based on the comments. Sometimes they don't. And then they will promulgate those regulations and make them official. That hasn't happened yet. So that's why these are proposed regulations. They're not official yet. They're not in place, but I think it's pretty safe to say you're going to see these all going pretty close to what they are right now. Next question. Does holiday or vacation time count toward accrued hours? And I think the answer to that is holiday or vacation time. Does that count as worked time? And I believe the answer to that is no, especially to the extent it takes away from sick. But let me confirm that for you. I will confirm that question for you and send that back to you. Let me just make a note. And the next question, how does everything apply to a contracted employee that has a start and end date of employment? So that's a good question. And the answer is going to be that contracted employee, if these rules and regulations are approved and are accepted in their current state, they're going to count towards the count, if you will, right? They're going to count towards the counts. And then the question is going to be whether the contract that you've got is able to which provides for or doesn't provide for leave, or provides for some other type of arrangement as it relates to leave, will somehow trump or overrule the paid sick leave requirements. I believe the answer to that is it will not. There are some exceptions in there that relate to unionized employees who are subject to collective bargaining agreements, and there's some interplay there that needs to be taken into account. But I don't believe that a contracted employee that has a start and end date of employment, remember, under these rules, they may have that time, they may be able to accrue that time during that period of contracted employment, but once that period, that term is over, they're no longer counted, obviously, as you saw in the rules. But I can confirm that also about this contracted employee issue. I think that during the period of their contract, they will be entitled to this leave, but I can confirm that as well. I'm just taking a couple notes here. Next question. Under current law, we front loaded all 56 hours. Okay, understood. Yeah. And so therefore and I think that's for the question of the person in March, with the who's having the birth of the child. I think that's a answer to the question that I asked earlier. Are 1099 employees included? And I think that goes to the contract employee issue. So again, remember, 1099s are not employees, right? W-2s are employees. 1099s, I'm fairly certain that 1099s are not included, because 1099s are not employees. 1099s are independent contractors. It goes to the issue, which is a whole other issue that we could have a whole other presentation on, and that's the issue of whether the individuals that you're counting as 1099 independent contractors really are bona fide independent contractors, or whether they are common law employees. And it's really important for you to take a look at that, because for any of you that have been through that issue with the Department of Labor in the past, where there's a misclassification claim against you. In other words, somebody says, well, you've got all these 1099s, but they're really not 1099s. They should be W-2 employees. Therefore, you owe us employment tax, you owe us workers' compensation premiums, penalties and interest on top of all that. You know, the individual has a benefit claim against you. For anyone that's been through it, that's no fun. And that's a very hot button issue for the state. They got a $30 million budget gap now. They're doing anything they can to raise dough. So be very careful about that. Paid sick leave now puts an additional layer of complexity on a claim like that, because they could come back on top of saying, you owe us, you owe us workers' comp premiums, you owe us employment tax that you haven't paid to these 1099s. You owe the individual, the benefit that they would have received under a health plan that you said they weren't entitled to. Oh, by the way, now you owe that person accrued leave time under paid sick leave. It's another layer of complexity as it relates to misclassification claims. So be very careful about that. But, again, making another note and confirming that 1099s are not included. 1099s are not employees. 1099s are independent contractors. So next question, if a company uses the accrual method and a new employee starts in 2021, is it okay to have them start at zero? And I think the answer to that is yes, so long as that's when they've started, and if you're using the accrual method. And again, I'll confirm, I'll get back and make sure that we've confirmed all the answers to these, but I think the answer to that is yes. Next, if you look at the requirements, reasons for taking New York State paid sick leave, it seems that you should not allow vacation to be charged against the 40 or 56 hours. I agree. And that's, that was why I made those comments earlier. You're not going to be able to effectively take away somebody's entitlement to this sick leave requirement by counting vacation or paid time off against it. So I agree with that. Will we begin to calculate 10/1/2021 towards 22 sick pay on the accrual method? I don't know the answer to that. But I will confirm that for you. Bear with me. And the answer is, I'm not sure. And the reason why is because one of the reasons they did it the way they did it this year, when they started in last fall, is obviously because they wanted to hit the ground running on Jan 1, 2021. And the only way to do that was to start accruing time prior to that. That's the reason why they did it the way they did it. What I don't think they meant is that was the way it was going to work forever going forward. I think they wanted to get it in place so that you're ready to go on Jan 1, 2021, with time. I don't know whether that'll happen again for every year going forward, but I'll confirm that for you. Okay, I just saw something stated the employee could not be penalized for taking this. Do we need to change our attendance policy to provide these as free days? If so, are we able to adjust our policy to be more strict above this time, or will be looked at negatively by the state? So I guess I've got this. I see this question. I'm not exactly sure what you mean by, if what you mean is I thought I saw something stating the employee could not be penalized for taking this. Yeah, do we need to change our attendance policy to provide these as free days? I'm not sure what you mean by that. If you want to email me directly, I can answer that question, because I'm just not sure. I'm not sure what days you're talking about. I just want to make sure I understand which policy you're referring to as well. So feel free to email me directly, and I can talk to you more about that. Next question. Most times we count employees, we use a full-time equivalent FTE number. This time it seems that we count each person regardless of hours worked. As an extreme, if we have an employee that works 40 hours in a full year, do we now owe them 40 hours of paid sick leave? So the answer is maybe. The answer is depending on the thresholds that you have. Although there's nuances there, which as it counts towards when the entitlement occurs, et cetera. So I can confirm that for you. I see that question. I'm making a note of who gave it, and I think the answer is possibly, but there's some nuance there that I'll confirm for you. Bear with me as I'm just taking a note. Okay. Does this paid sick leave roll over to the next calendar year if not used? And the answer is, in some instances yes, in some instances no, in many instances no. But let me I'll confirm those numbers for you, and I'll get that to you. And again, I've got notes here. And I can get these back. I'll make sure that I've got these back to everyone. Does it make sense? Can I just send these? Bear with me one second. So what I'll do is I'll confirm all this information this morning, and I'll circulate. I'll get these to everybody. I've got the names of everybody who has asked these questions that I haven't addressed already, and make sure that I get their contact information, and we'll email you, either all directly or through the chamber, if that works and makes sense.
Yeah, either way, Chris, that we can help coordinate that.
Right, and to the extent it's not on there, so again, yeah, and somebody just said, can you send these answers to me as well? And I will. I'll send. So I'll go through the chamber and answer those questions so everybody can see them and get the answers. So, and then again, when you get it, I'll make sure too that you've got my contact information to the extent that it's not all on the slides. I think it is, but if it's not, you can feel free to email me. I'm working at home, as you can see from my background here. So if people want to call, I'm taking calls all the time, and I'm happy to discuss. And, again, I appreciate the fact that this is this is a new world and not practical in many instances, and difficult to handle. So I appreciate that, and we will we'll help you navigate through all this. But I'll get answers to these so they can be circulated to everyone. And if there are further questions, please do not hesitate to shoot me an email or give me a call. Other than that, thanks everybody very much. I've enjoyed it.
Thank you, Chris, and thank you for filling in on such short notice and still putting this presentation on for everyone today. And I just would like to lastly mention, if anyone who is not a chamber member is on and you're interested in membership, you can always contact the chamber at info@chemungchamber.org or call us at 607-734-5137. And again, thank you to Chris and everyone for being with us today. We'll send you that presentation, again, the recording of today and any other information that Chris can share with us.
Thank you.
Thanks, everyone.